gentlemen, welcome to the People's Law School. It is my privilege tonight to present to you Coby Boswell. He specializes in divorce and family law, and that's the topic upon which he's going to speak tonight. I look forward to and proud to present Coby Boswell. Thank you. It's good to see you.
Appreciate everybody coming here tonight, and we're going to talk a little bit about some fun topic of divorce. And the one good thing about what I get to talk about and what I get to do every day is most everybody has had some sort of experience with divorce. I don't only do divorce, I do child custody and modification and adoptions and all kinds of other actions related to family or domestic relations law. But we're going to talk about divorce tonight. But most everybody, and I think from a show of hands I would think if I asked everybody who all has had a family member or has been divorced themselves, I would suspect everybody's hands is going to go up. But what my experience has been in practicing in this, and as Mr. Brinkley was talking about, I started with my current firm prior to me graduating law school, and I actually had my law practice card, was practicing prior to me even graduating and taking the bar. And the way that kind of works is kind of like a learner's permit. It's just kind of like like you would with your driver's license. I was able to drive the car, but I had to have somebody in the seat next to me. But what I've been able to determine in practicing and doing domestic relations is that while a lot of people have experience with it, there's not a whole lot of information that people have that is actually accurate, which seems surprising. I can't tell you how many times I get people coming in saying, my husband or wife said that I'm only going to get this from the judge, so I've just said that I would go ahead and settle. And I can't tell you how many times I have to tell them that if you'll just take a minute and think about who's relaying the information to you and you understand, you might realize that there's some bias in that information. And that's the hardest part about the divorce process. You spend a long time, most of the divorces that we see that get to the point of litigation are longer term divorces. When you've got divorces or marriages of 2 or 3 years, the people are able to, generally speaking, resolve those amongst themselves and maybe with the help of an attorney, and we'll talk about that. But at the minimum, they don't generally get to litigation. Where we see those get litigated are in 2 areas. We always fight over children. No matter what we do, there's always going to be some sort of disagreement about that. It's very difficult to craft and think of every aspect of your children's lives and what might be involved in that, and how to delegate parental responsibility as a result. So now our judges here have done a good job of creating some standard schedules, some standard parenting clauses, and some other things that help guide parents. But that's one of the big things that we argue over in our divorce actions is children in custody. The other one is when we have long-term marriages. And that tends to be the ones that are harder to resolve because you've got people who have become dependent upon each other for their everyday survival. And it becomes very difficult to separate that and come up with a figure that everybody can live on separately. I vividly remember one case that I tried in front of Ruth Ann Hall here in Madison County, and she called both parties out in front of her, and she basically told them that neither one of them could afford to live separately, that they both were going to have to go into poverty to do so, and they might want to sit down and try to figure something out to make it work. Now, you won't be surprised that they were able to reach a result at some point, and they were able to sit down, but that's not unusual nowadays. Unfortunately, everybody has access to loans and to other things, and on occasion people overextend themselves. And so it's very difficult to unravel that process in the divorce. But that's the task that we're charged with doing. And one of the first things that I want to talk about is in order to get a divorce, it's pretty clear you're going to have a marriage. And there's 2 types of marriage in Alabama. We're one of the few states that still carries common law marriage, which is very antiquated. It comes from the Old English law, and quite honestly, our courts somewhat disfavor it. It's not something to be used but in sparing situations. But one of the factors in a common law marriage, and that's a situation in which you've not had a ceremony, gotten a marriage license, and proclaimed to the county or to everybody, your family and friends, that you're going to be married. It's just by circumstance, the court and the law is going to declare you guys to be common law married. But the factors that the court looks at in that, one of the most important ones is, have you guys resided together? In order to be able to establish some sort of common law, there has to be some sort of joint cohabitation. Now, it doesn't have to necessarily be 100% of the time. You can have people that spend time in vacation homes and, or seasonal, but there has to be some sort of cohabitation. It's very essential to what the court is going to evaluate. But after that, it's kind of a fact-based scenario. And you're going to hear me say that a lot here tonight. A lot of what I do, while it is structured in the law, is really fact-based. Everybody's situation is different. Your situation may be totally different than hers. And the court has to work within certain parameters, but the benefit is that we can get very creative at times. And that's why when you see some of these settlements, or you talk to people about their experience in the divorce process or reaching agreements, it can be very vast across the board as to what that experience is. You may get one person that felt like it went a totally different way than the other person, and they can't reconcile the two. But everybody's facts is different, everybody's situation is different, and this law is so much based on, you know, what the situation is, and you'll hear me say this a lot, the court looks to what's the best interest. That's what the standard that we generally use in initial divorce actions with respect to kids. It's what's the best interest of the children. And as you might expect, everybody kind of disagrees on what's in the best interest. We might have, it can be a variety of different people. We have the plaintiff and the defendant. Neither one of them want to agree on what's in the best interest. The attorneys certainly aren't going to agree what's in the best interest. And on occasion, we have an attorney for the child, which is called a guardian ad litem, and they may not agree what's on the best interest. So the judge's job is very difficult in family law cases. They are generally highly emotional. They are, most of the time, people sometimes check ration at the door, okay? They do not, it takes a long time to find rationality and to find some resolution to these cases. So a lot of our divorces will linger in the court system for as much as 2 years. And some of that is by design. Some of it is because people become more willing to negotiate things the longer they have to endure this sort of stuff. And the reality of it is we have a lot of divorces. If you know, I don't have the statistics here in front of me, but it doesn't take a lot to determine that the rise in divorces is going up while the number of marriages is going down. And what that means is we have a lot more court actions because we have a lot of more unmarried parents that are going into court. We're not going to talk about that today, but they go into a different court. But we also have a lot more divorces. And the reality of the divorce process is if you have children, you're going to go back to court multiple times, especially if you get divorced at an early age or your children at a young age. You're going to go back. It's unfortunate, but that's just the reality of the situation. So you become very familiar with the process. You have to go through it. And in that, you kind of learn some of the more important things. And what I try to tell my clients is you really get down to what's important and what can be put aside. And you start putting aside some of the hard feelings. But to get in there, like we were talking about the common law, and we talked about some of the factors. Some of the other factors that the court's going to look at is, do you guys share bank accounts? Do you hold real estate in your name together? Did you file taxes together? Did you get benefits in the same name together? All of these are factors that the court considers, but not one alone is going to rise to the level of common law marriage. Again, it's going to take a multitude of these things to get to that level. And again, the case law is very clear. The court disfavors common law. They really would prefer that under all circumstances we try to find a resolution absent of a common law marriage. And the reason for that being is you would hate to put people in a position where they're forced to get a divorce when they maybe didn't necessarily have the intent to get married. They just kind of operated as a married couple and woke up one day and realized they were married. That's not really the way the court system wants to work. We would prefer that people actually go and get a license and they announce to the public that they want to be married before we divorce them. And that's typically a divorce that we're going to see. Common law is very, very minor. We do not see it all that often in our practice. Of course, as I say that, right now we have a case going where that is one of the arguments. So, but it's a very rare thing, and it's very disfavored by the courts. The traditional divorce and the traditional marriage is what most people see, and that's what you mostly see in the divorce process and through the court system. Now, that's just like everybody would imagine. That's where you go get a marriage license, or you have a marriage ceremony, you have somebody sign off on that, and you file that with the probate court. Once you do that, the state of Alabama is going to recognize you as married. And the only way to separate is to get a divorce. And it's just the reality of it. And so in doing that, there's a couple of different ways you can get divorced. Most people will tell you there's only two ways. There's an uncontested divorce or a contested divorce. I generally say that there's three. I generally call the uncontested divorce a unicorn. I don't believe it actually exists out there. Most people believe that they've resolved things, believe that they want to reach a settlement on things, but they really don't have a full understanding of what they need to resolve. And that's where the attorney comes in, and that's where our process plays in this. We have to help them set up these factors, because one of the more important things about a divorce settlement is it's a final settlement. Now, with respect to custody and child support, and in certain cases some alimony, those things can go back to court and be relitigated. But when you settle property, or you settle marriage rights, or what you're going to get as far as personal property, monetarily or otherwise, that's final. You get one shot at that. So it's really important that you get it done correctly. I can't tell you how many times people have come into my office wanting to modify a property settlement, and that's a very difficult conversation to have. You know, as attorneys, we never want to be able to tell people that they have no remedy. You know, we want to try to find a remedy everywhere. Unfortunately, the law is very clear with respect to that. 30 days after a divorce is entered, a property settlement is final, and it will not be modified under any circumstances. The court actually loses jurisdiction to modify it. So it's not even that they don't meet the grounds for it, it's the court doesn't even have jurisdiction to hear the case anymore. And so it's really important that before you enter into one of these things, or before you have somebody come and sit down and want to go through a divorce, that you go through all the different processes with them, and you make sure that you cover all your bases. Because like I said, if you don't get it right the first time, you're never going to get another shot at it. And sometimes when you're dealing with these divorce actions and you're dealing with long-term marriages, it's important you get it right. This may be the only opportunity that person has to continue to support themselves, to be able to flourish or stay in the lifestyle they've grown accustomed to. And that's a pretty heavy responsibility. Before I went to law school, I sold real estate for 6 years. And one of the things I liked about selling real estate was I got to work with families. I got to work with people and putting them in one of their biggest, most important, purchases in their life, a home. It's a joyous experience, it's a fun thing, and it's a really important day in people's lives. But that's also what drew me to divorce law. I get to play a role in people's lives that's incredibly important. Now, it's not always one that they want me to play, and certainly I've had the comment on a number of different occasions, I truly enjoyed it, but I hope I never have to see you again. And that's okay. That's part of the process. The reality is over half of them are going to come back and see me. But it's okay to not be comfortable with the divorce process. It's uncomfortable for everybody. It's personal. It gets into your business. If you go to trial and you have a final hearing, you're going to be in front of a judge. Your spouse is going to be there. It's open to the public. Anybody can come in there and watch. All of your dirty laundry is going to be aired. Everybody's going to get to know all of your business and be involved in your personal lives. That's not something that most people, if you told them up front, would want to be involved in. But a lot of times, the emotions and the acts that lead to the divorce overwhelm that, and they don't realize that. But we try to counsel our clients, and I know that Madison County's got a great set of domestic attorneys, and all of them try to counsel our clients on just trying to reach a settlement. And unlike other cases, litigation is not your best friend in divorce. The court is bound by certain parameters, and we're going to talk about some of those, but one of those is they have to do what the evidence is presented before them on what they believe is equitable. And what that means is what's fair. Now, again, we get into this topic about who determines what's fair. Well, both sides are going to present some evidence about what's fair with respect to division of personal property or division of real estate. But are those probably going to be the most fair responses? Probably not. We have some judges. I know there's a judge in Limestone County here that when he deals with personal property, one of the things he loves to do is he tells both sides to prepare a list. He says, I want each of you to prepare a list of what you want and make it a fair list. And then I'm going to have you guys exchange the list. And what you will find is one person will make the list pretty one-sided. They'll make it for themselves, and they'll take all the things that they want, and they'll award the other stuff that they really don't want to the other side. And then that judge will take the list and flip-flop them and award them the other direction, because that is what they would deem was fair, because that's as fair as anything else. And that's the reality of what we deal with. It is such a wide spectrum of what can be fair that it depends on what you present to the court as to what relief you're going to get. And that's a scary proposition when you're going into court. Most attorneys will tell you they really like to know with some pretty specific accuracy what the result's going to be. If you go into a divorce proceeding, you really don't know. No matter what the testimony is going to be, even if you rehearse the testimony with your client, you go through it, you think you've uncovered every rock, it takes one question to get you down the road on something that you never discussed, you never knew about, because this is personal. There's a long time for you guys to develop all of these little problems and these other aspects that come into this divorce. When you're talking about a 20-year marriage, there can be things that come up that you never even thought would come back up from 16 years ago that may be relevant in the case. You can never be prepared for that. So when you go into court, you're putting a lot into the judge's hands to ask you to do that. Now, I know that if I ask most of the people here today, if I wanted somebody to come into your house, divide up your personal property and award it to people without asking you your opinion, most people would not agree to that. And I know myself included would not be comfortable with that. That's why we encourage people to reach settlements. But let's kind of back up a little bit. I want to talk a little bit about what court we're talking about and how we get into that court. As you guys are aware, there's a couple of different courts in the state of Alabama, but when we're talking about the county, we're talking about district court and circuit court. All domestic relations actions, all divorce actions arise out of circuit court, whereas all child support actions and all paternity actions go to district court. Now that's confusing, but the way it works is if there is a marriage, the circuit court is going to take it. If there's not, it's probably going to the district court. Now there are some limited circumstances in which you can go back and forth between the two, but that's the general rule as far as that goes. With respect to where the court is going to be. Now that's one that I have all the time as to, well, I live in Madison County, my spouse has moved to Limestone County, where do we file the divorce? Well, it depends. And that's our favorite answer as attorneys, it depends. If you are going to be the plaintiff, you need to file the action in one of a couple of places. You either need to file it where the marriage occurred. So if you guys resided in Madison County and one person moved to Limestone County, you can file it in Madison County. You can file it where the defendant resides. So you can move to Limestone County and file it in there. Those are the two options in the scenario I gave you. Now, you do get into some crazy scenarios when you have out-of-state residents, and that comes into some other case law, and I don't know if you guys have ever heard the case, but it's called international shoe. And what that is it deals with minimum contacts with the state. And the court can divorce parties as long as one party has some contacts with a resident state and the other party has some contacts with this state. Now, I'm not going to get into what the minimal contacts is. Again, that's a fact-based scenario. The court has some wide discretion in determining some of these things. And you're going to hear me say that a lot tonight, discretion. It's one of the biggest things that the court plays and uses in the divorce process. When you appeal one of these cases, it's always to a standard of abuse of discretion. Well, almost always, unless you're dealing with an aspect of the law. But when you're dealing with the court's decision with respect to division of property, award of custody, or even the divorce, it's going to be the discretion of the judge. The court's opinion, the appellate court's opinion is, they're in the best position to look at the witnesses and make a determination. They can see them, they can see their facial tics, they can see whether they were nervous or not, and they can judge their veracity based on that and sitting there. So the court's not going to overturn those unless it's pretty clear that somebody didn't follow the law, or there was something that was missed, or like I said, a evidence or a law conclusion that was either misapplied or you know, not exactly followed to the letter of the law. And that's kind of what you're going to see. But in these types of actions, again, it's all based on the evidence you bring to the court. And it's all based on what the evidence is in the record. And so it's very important that in the initial part of the divorce process, you sit down with your attorney and you get a good landscape of what's going on. One of the exercises I like to do with my clients is I like to have them sit down and make me a list. And I tell them to divide it into 3 columns. And I find this to be a very useful exercise in dealing with divorce clients and divorce litigation. In the far left-hand column, I tell my clients, I want you to put the absolute must-haves, the things that I cannot live without, I would fight to the end of the world to have, and I will litigate this case for the next 10 years if I have to. Those are pretty important. As you would imagine, if you got kids in the divorce, most of the time, those end up first on that list. Not always, but most of the time. The other column, the far right-hand column, these are the things that you don't care about, that you're willing to give to the other person without any kind of fight. For instance, I've had this on a number of different occasions. Military memorabilia. One person's got it in the house still, the other person wants it. Nobody's going to fight over that generally. Most of the time people are going to give that stuff back. So you put that in that column over there. That might include the leaf blower and the lawnmower and things like that. It may not. The middle column is the most important column, and this is the one that I like to deal with the clients, and this is where you figure out how long the divorce action is going to take, how litigated it's going to have to be, and whether or not you can find a resolution or not, or you're going to have to go to a final hearing. This middle column is what would I like, but I'm willing to give up to make sure I get that first column. The negotiable part. And here's the thing. Everything is negotiable when you're talking about a divorce, because everybody owns everything in a divorce. This is one of the biggest misnomers that I deal with. I get people that come in and they'll talk to me and they'll say, well, that car doesn't matter, that car is titled in my name. Or, well, I have that house, but that house is titled in my name. Well, that's not the way the divorce process works. Once you guys marry, you guys each party gains a marital interest in everybody's property as long as it is used for the common benefit of the marriage. And this is important. If you have certain things that are not used for the common benefit of the marriage, one of our biggest examples, and there's a case out there that deals with this, it's called Bushnell, but it involves inheritance and it involves outside funds that were received by a party prior to the marriage and how they were used. And the idea behind it is, if you segregate these funds, if you have an inheritance, and you do not use that for the benefit of the marriage, it's separate property and it's not subject to division by the court. But as you can imagine, it's very difficult to not tie things back that have been commingled to some degree and used for the common benefit of the marriage. Even if you have this inheritance, if you were taking dividends off of it and paying your mortgage payment, you've probably commingled those funds and they're probably subject to division. If you've taken some sort of funds and invested in some investment property, which now you are using and dividing with your spouse, you've probably commingled those funds and you probably have used them for the common benefit of the marriage. So the biggest thing that I tell people is when you sit down, everything's on the table. We can start eliminating stuff based on our conversations, but nobody should go into that process thinking, I'm going to keep these certain things because I had them before, and I'm going to keep this because it's titled in my name, and this is my car, this is not her car. That's not really the way this process works. And I know that a lot of people have some confusion on that issue because I deal with it on a daily basis. And it may not make the most logical sense. You know, a lot of people think, I bought the car, I had the car before, it was my car, why should that person have any right to that car? But then you start thinking about it. Did somebody else give up something? Did they make a trade-off to let me drive that car? Did that car break down and I have to use some marital money to fix that car up and get it running again? And that maybe cost them getting a new car or leasing another car? That's how these things get commingled and how you start having to unravel these lives. I mean, this is the situation. You've got two people who have commingled their entire lives that now they're asking you to take a meat cleaver and separate it. It's not going to be a clean process. That's why we encourage people to settle. And I know I've said that a couple times. You're going to hear me say it a few more times. I tell all my clients, I've been told you have to say things 3 times to be able to remember them. So I tell them 3 times in the first 5 minutes, and then I tell them 3 times again at the end, just to make sure that they understand what all's going on. But once we get into court, or once we determine where the action is going to be filed, again, we talked about there are a couple different types of actions. If you have the uncontested, like I talked about, the unicorn, then the 2 of you guys are going to reach an agreement. You're going to have an attorney draw it up, and we'll go through the agreement, and they're going to cross all the T's and dot all the I's. Everybody's going to sign off on it. You're going to file it in the county, and the judge will sign off on it. Now, it must sit on the judge's desk for 30 days. This is called the cooling off period. And the idea behind this is on occasion, people have marital disputes. On occasion, people do rash things, and they may change their mind in that first month. You'd be surprised, but I have seen it. I have also seen other people tell me that there's no way they would ever change their mind after they filed it. But it is called the cooling off period. It's very important because the judge has no jurisdiction at all to sign an order until that 30 days has run. A lot of times we see a lot of different action go on between that 30 days between the order is filed. And so it's important that everybody understands that going on, or going into the process, so that they don't get any kind of misnomers or misunderstanding about what they're able to do. Because the other part about that is you can't remarry for 60 more days after the divorce is entered. Now, most of the time when I tell my clients that, I get a chuckle. Fat chance that's not going to happen anytime soon. You would be surprised. I've had at least 3 clients that have sat down with a calendar and planned their second wedding in my office, counting out the 61st day. We actually had one client that they were slightly upset with the order, but instead of filing something to change it, they'd already sent out their wedding invitations for the second wedding, so they just let it go. As you can imagine, we're still having to deal with that issue later on, and it's caused other problems. But you would be surprised how many people want to jump right back in. It's important that you understand the divorce process, at minimum, it's going to take 90 days, at minimum. But that's in the best case scenario. That's over here, like I talked about. That's the unicorn. I'm not sure they actually exist. The contested's on the other end of the spectrum. And we're going to talk about that one in a minute, but that's what everybody knows. That's the one where everybody goes to court. You fight it out. You can't agree on whether it's, the sky's blue or whether it's up or down. That's the contested action. I have what's a third action that I've kind of created, that our office has kind of developed, and what we call a negotiated uncontested divorce. And what that means is just like you think. We think that we can reach an uncontested divorce. We're pretty sure that these people are not going to continue to fight with each other, and that we can resolve some of these differences based on what we've talked about and what we've heard from both parties. But it's going to take a little bit to get it over the hump there. A lot of times, these are where all of our uncontested divorces fall, because most people agree that they want to get divorced. Most people agree that they want to sell the house and they want to split the house. Most people can even agree on the custody of their children. We want to split time, we want to share time. But what does share time mean? Are we going to divide up holidays? When are we going to divide up the holidays? How are we going to divide up the holidays? Who's going to get Father's Day? Who gets the kids on their birthday? What are we going to do if there's a death in the family? These are all things that most people don't think about. With respect to personal property, you guys everybody's got a car. Everybody's name, both people's names are on both cars. How are we going to refinance that car? What happens if we don't refinance that car? What happens if they stop making the payments? What happens if the house doesn't sell? These are all questions that most people maybe think about, but they haven't resolved by the time they come see an attorney. And these are important things that you're going to have to go through. Because like I talked about before, if you don't get it right the first time, you don't get another shot at it. And as attorneys, that's pretty important. That's where we get to call our malpractice carriers, because we've done something wrong and we can't fix it. So it's really important that you go through and you get all the information from the clients. That's where you sit down and your work starts on day one with the consult with the client. You want to make sure that you keep them informed. You want to make sure that you tell them about the process. But most important, you want them to go ahead and start getting documents together, start getting information together. And that's where we talk about the discovery process in the divorce action. Now, this is after a contested complaint has been filed, but the discovery process is a very useful tool in a divorce action. You guys have probably been familiar with it in some of the other speakers in talking about discovery, about sending over interrogatories and requests for production of documents and things like that. But in a divorce action, it's essential. In fact, it's a requirement. And if you're not doing it, you're probably doing a disservice to your client. The only scenario in which we don't conduct full discovery is when we have an uncontested divorce, or when people are bringing in this information and we can agree on what everybody's got. But it's incredibly important that you utilize discovery and that you make it a thorough discovery process, because this is the only way you're going to get this information. Again, this is personal information. This is private aspects of people's lives. If you're not asking them this question, who else is going to know? One of the biggest things that we do with our discovery is, and there's three types of discovery that we generally use in a divorce action. We have what's called request for production of documents. And depending on whether those are served with a complaint or not, you have 30 days to answer if they're not. If they're served with the complaint for divorce, you have 45 days. Reason being is they generally require a lot of information. So we give them a little bit of extra time because they're going to have to answer the complaint as well. But the discovery process, the request for production of documents, is just like it sounds. We want you to produce any document that we've asked for. Now, what are some of the typical requests? Tax returns. Those are one of the big ones, all right? Generally speaking, even though you have married parties, one person files the taxes they're responsible for it, and one person is not. One person knows where they're located, one person doesn't. You need to have those to be able to work off of, to be able to get a divorce, and to be able to determine what everybody's got and how you divide it up. One of the other things that we deal with in request for production of documents is, what surveillance have you conducted on your spouse? What text messages, what communication have you had with your spouse? Are you claiming they're a bad parent? Well, what do you say, what is the reason for them having being a bad parent? And what is that evidence that you have to support that? Do you have videos? Do you have pictures? Do you have doctor's reports? What do you have, and provide it to us? The divorce process, it's not trial by surprise. Okay, you turn over everything. Everybody knows everything prior to them getting to court, or they ought to. Now, the one axiom I think that you guys probably have heard is clients don't always tell you the truth. Or if they tell you the truth, they don't always tell you the whole truth. It's important that you remember this, you recite it every day, and that you make that a part of your practice. Because if you're not asking the questions, the client may not know that they need to be telling you that. And you're the one that's responsible for making sure that you get the information. So if you've got a client sitting down and you don't ask them about whether or not they've had an affair, and then you start making allegations the other party's had an affair, and it turns out that your client might have too, that's a problem. And that's probably not a can you want to open up. And it may not be the way you want to style the litigation. You know, I get a few chuckles in here, but you'd be surprised, I've actually had that scenario as well. I've had a party come in and talk about all the wrongdoings of the other party and go at length ad nauseum about all of these things, and I prepare a complaint for them, and you know, we write it up just like they say, and they approve it, and they go through it, we make some changes, and we file it in, and about 2 weeks later I get a call from them and say, are the other parties going to ask the same thing and say the same things to me? And I'm saying, well, it's possible. Well, is there a reason for it? And then the truth starts coming out. And the problem with that is you're kind of already committed down a path, and you may be doing a disservice. So it's important that you ask the tough questions. Nobody wants to talk about affairs or talk about what's led to a breakdown in a marriage. Again, it's very personal. This is a very difficult subject for people to talk about. But you've got to ask those questions. They come to you for a reason. I tell everybody that comes in my office, there's probably not something that you're going to tell me that I haven't heard. And if you have, it's probably good, because the judge probably hadn't seen it either. Because most of the time we have seen it all in family law. That's one of the beauties of what we do. We go to court probably more often than any other attorney out there. We're in court 2 or 3 times a week. And that's because it requires so much back and forth over little things. I go to court sometimes on just whether or not one parent can pick up a child from school at 3 p.m. or whether that child has to ride the bus first and be picked up at the home. That's probably not the best use of the court's time, but sometimes that's just the way it works, and that's the way parents are. But that's also why it's a responsibility of a domestic attorney to counsel their clients on trying to reach a settlement. It's so important. People in a divorce action have a great deal of ability to reach a settlement that is very creative. It can be very vast, and it doesn't necessarily have to conform with what the judge might do. What we tell people is you can pretty much agree to anything that's not illegal. And you'd be surprised that some people want to put some stuff in there. But you guys, as two parties entering a divorce action, I mean, you're asking the court to invade your personal life, your personal home, and make a decision by listening to you for 4 or 5 hours at most, maybe 2 days to listen to you. How many people in this room, by show of hands, can tell me their entire life story in 4 hours? That's what I thought. And if you do you think you're only going to get the highlights? Now, what if you go to court and you got somebody else who only wants to show all the negative parts about you? Because that's generally what happens in these actions. People don't get up on the stand and spend 20 minutes talking about how great of a spouse this person was, how great of a provider they was. You know, they went to their job every day, they provided, they paid all the bills, they were just the best, but I don't know that they're the best parent. You don't get that, guys. What you get is everybody talking all of the negative things. So can you imagine how difficult a judge's job is? They hear all of the most negative aspects of people's lives. They have to determine, based on all of this negativity, who's better and what's in their best interest and what's more fair and equitable to award to them. I can't imagine a worse scenario in allowing a judge to do that. It's just not set up for a position where you're going to get the best result. Everybody's slinging mud. And that's why I continue to harp on and reiterate reaching a settlement. But let's talk a little bit about what a settlement entails. And that's important because you must go through certain things. And one of the first things you've got to establish, like we talked about, is, does the court have jurisdiction? Do they have jurisdiction over the marriage? Did the marriage occur in Alabama? Do they live in Alabama? It's got to be stated in your settlement agreement. If it's not, the court's probably going to kick it back, and they're going to ask you, what's going on? How come you're not telling us where the parties were married and why we have jurisdiction to divorce you? One of the other things they've got to talk about, you've got to tell the court whether you have children or you don't. And this one might surprise you. You've also got to disclose whether the wife is pregnant or not, because it's important. Under Alabama law, if you have a child born within 300 days of a marriage, and you are presumed to be the father as the former husband, regardless of whether that child is actually yours. Now, that person is the only person that can disclaim that parentage at that point. So if that person wants to be the father of that child, even if they're not, they can do so. Now, how scary is that? That's a pretty scary phenomenon to think that your ex-spouse can have that much control over you after the fact. But if you don't disclose the fact that you're pregnant prior to the divorce being filed, even if it's somebody else's child, even if it's determined by DNA to be a biological child of somebody else, that person's maybe the father. And you've got to deal with them for the rest of their lives with respect to custody, with respect to graduations, with respect to marriages, and all the rest of that. Now, that may not be something that everybody wanted to sign up for, but how simple was it to just go ahead and disclose that you were pregnant? It would have been a lot simpler than that, but a lot of people don't think about that sort of thing. The next part that you want to talk about is, how do you get into court? You need to tell the court what actions were filed and how they got there. It's important to kind of set up for the court. A complaint for divorce was filed, an answer was filed, and the parties reached an agreement. They need to know that there was some paperwork that established their jurisdiction over this case. Now, we all use AliCourt now. This is a wonderful e-filing system, but just like technology, it doesn't always work 100% of the time. And I have seen files go missing. I have seen things not be on AliCourt that were supposed to. I've seen things filed in the wrong case file. So it's important that you follow all these steps in each one of these pleadings and you put all this information in. It may be a little redundant, but it's important that the judge is able to independently look at each document and know that they have the right to enter in the relief you're requesting. But one of the next things that I do is I talk about, it depends on whether or not you have children or you don't. Because one of the things that I like to do is I like to address custody and children first in my agreements. Reason for that is, and again with a caveat, the majority of people, this is their most precious commodity. You can't imagine anybody being more zealous about what happens to their child and how that is than when it comes to children. That is the most important thing in the majority of the cases that we deal with. It is probably the reason that we go to court. I don't want to hesitate to put a statistic on it, but I would say at least 70% of the time we're arguing over custody, visitation, child support, issues related to children, the lack of support, the payment of expenses and things like that. I tell most people, you know, when you sit down, I can divide up money. We've got wonderful calculators and tools, and you can get money and you can get creative with that sort of stuff. They determined a long time ago that we don't chop up children and divide them up like that. So we got to sit down and we got to come up with a resolution. There is no creative way to do that. But the beauty of an agreement is they can work around and the two parties can enter into agreement that works with their schedule. And this is a very difficult thing, and it's something that's really overlooked by a lot of parties. When you file a contested action in our court and you go to a final hearing, and there's two types of custody, and we'll talk about that in a minute, but if one party is awarded custody, our court in Madison County, and a lot of these surrounding counties have similar things, they have what's called a standard visitation schedule. And what that is our judges, and they've done a wonderful job, we put a lot of effort into this, they have crafted a schedule that affords the other parent some regular visitation. And what the court has held is that without some sort of schedule of visitation, it's not a valid divorce. It's not a valid order. The way they used to do these divorce orders and the way they used to handle these sorts of things was they would leave any dispute when it comes to visitation. If the parties were reaching an agreement, they would just put in there, as the parties can agree, or at the discretion of the wife or at the discretion of the husband. As you can imagine, that didn't go over that well. We had to litigate quite a few cases. The reality of it is time intervenes. And when time starts intervening between two parties, their memories start to fade. And what they agreed to and what they were willing to do with respect to visitation of their children, and whether they were always willing to give the mother Mother's Day or whether they were always going to give them a special holiday or not, that might fall away. And when you have one party that has the discretion over another party's visitation with their children, more often than not, we see at some point that be abused. For one way or the other, we see both parties abuse it. And that's why the court, there's some case law that came down that says you must have a schedule. And our court has developed this standard schedule. And I'm not going to go into all the specifics of it, but generally speaking, they allow for 1 day a week. In our county, it's Thursday, and then every other weekend. And the idea behind that is we tried to change it so that the schedule would flow from Thursday to Monday. We wouldn't have the kids going back and forth between houses. But what our schedule also does, and this is the one that I think most people forget when I sit down and write an agreement with them, they determine holidays, they break them down. You'd be surprised. I had one the other day, I had a call from a gentleman, and he was talking to me about what holidays were covered, and we flipped to the schedule, and Halloween and Veterans Day, and some of these things that you wouldn't really consider as really big holidays, they're covered on there. And that's because we have determined that when you allow parents to make these decisions, over time, things start to fall apart. And so it's very important that we get these schedules. That's why our court has developed this. But what our court does is they've come up with a schedule that tries And I'm very hesitant in using this term, especially here in Madison County, to say equal. I find that I deal with a lot of engineers, and when I say the word equal, I get calculators brought out and we start counting the days down. And I actually had one person break it down, and we did an exchange at 2 o'clock in the afternoon on a Thursday for the children, because that was exactly equal in time. So I'm very hesitant in that. I say balanced or some other synonym for equal that doesn't exactly mean equal, because that's somewhat impossible. But what the court does is they try to give some time sharing to both parents. Now, our standard schedule implies that one parent's going to have custody over the other. And that kind of leads us into our discussion about custody and the types of custody. Most people, when I come in, the most common comment I get from people when they come in to see me is, I want full custody. That, again, is a misnomer. I think there's some misinformation out there as to what custody is. Full custody can mean a lot of different things. It's important that you understand the differences in the types of custody. There are two types. There is legal custody and physical custody. Now, physical custody is what most everybody is going to pretty much imagine. It's where the child or children are going to primarily reside. That's what you typically think of when you think of custody. Well, they're going to stay at mom's house most of the time and go visit dad. Or they're going to stay at dad's house most of the time and go visit mom. But that's not the only type of custody. In Alabama, the legal custody involves decision-making with respect to the children. Now, there are two types and subsets of each type of custody. There is joint and sole in each category. And we're going to talk a little bit about both. Let's start with the legal custody. When you talk about joint legal custody, this means that you guys are going to continue to operate as co-parents. You're going to inform each other on decisions, major decisions concerning the children. For instance, one of the examples I like to use is you're going to take one of your children to the doctor because the school has determined that, you know what, my child may have ADD. They're struggling in school a little bit. We're seeing some attention problems. We want to get your child evaluated. So you set up an appointment with the doctor. Well, what's your responsibility to the other parent? Your responsibility is first, when the school calls you and tells you that they want to evaluate your child, under a joint legal scenario, you need to call the other parent. You need to tell them that the school wants to evaluate that child and why. Most people miss that step. Okay, we get to the point where they schedule the doctor's appointment. We may even get to the point where they go to the doctor's appointment and then they tell them after the fact. That's not what joint legal custody means. It means that you guys are going to share equally in the decisions. But as you can imagine, the parties wouldn't be getting divorced if they could agree on everything. So we have to create some scenarios, what I call tiebreakers. And that's where the physical custody designation comes in. If you have a sole physical designation, and I did kind of skip over the sole legal, we'll come back to that in a minute, I'll explain the sole legal custody. But if you have a sole physical custody designation, it affects the legal decision making as well. And the way that works is, once you have somebody declared as the primary parent, that person has what I call, and it's pretty apt right now, the trump card. And what that means is they're going to share in decisions with the other parent. They're going to keep them informed. They're going to talk to them about these decisions. But in the event of a dispute, they hold the tiebreak card. They're going to make that final decision. So in my example, the school wants to evaluate the children for ADD. I call the other party and I tell them, the other parent, I tell them that the school wants to do that. They're reluctant, but they agree to the testing. We go to the doctor's appointment. We tell them about the doctor's appointment. They're reluctant, but they're okay with the doctor's appointment. The doctor does the testing. It comes back to say that your child does have ADD and the doctor recommends medication. At this point, you're going to discuss that with the other parent. Now, the hope is, if you're operating under a joint legal scenario and the two of you guys are co-parenting effectively, y'all will both be sitting in that doctor's office together, or will have talked to the doctor at minimum, and you guys will both come to the same conclusion and make the same decision. But again, our parties wouldn't be getting divorced if they could agree on everything. That's just the reality. So in that scenario, The primary physical custodian will discuss it with the other parent. They will talk about what their concerns are. The other parent doesn't want the child to be medicated. They think maybe it's just they need some extra activities. Let's get them in basketball. Let's get them in baseball. Let's get them in dance. Let's get them active, and maybe that will solve the problem. Well, the primary parent is going to discuss that with the other party, but ultimately they make the final decision. And if they believe that medication is what is necessary, they're going to make that decision. But with that comes a caveat. You better be making a decision that's in the best interest of your children and not in your own best interest, because that is one of the factors the court will consider if and when you ever have to go back to address custody. They're going to wonder, are you making decisions for you or for your children? And if you're not making decisions for your children, you're probably in a position where you're going to have to do some explaining to the judge as to why the other person shouldn't have more time or even custody at that point. The other type of custody is joint legal, joint physical custody. Now, this is more and more in style now. We have judges that are wanting to award this more and more often because we're seeing parents that have been sharing the responsibilities more and more often. Traditionally, 25, 30 years ago, you had one party that would work and one party that would stay home and care for the family. That tradition has changed. As it stands now, most of the parties, we have two working partners in a marriage. With that becomes sharing responsibility for getting them to daycare, getting them to school, dropping them off at their daily activities, and such as that. And in that, we have two parents who have adopted equal responsibilities for their children, and the court views that they're both operating as equal parents. Let's give them a shot to be equal parents. Now what that means is, again, and I hesitate to use the word equal, but it's a balanced time-sharing arrangement. And what that means, generally our schedules involve a couple of different things. They either involve a week-to-week schedule, which means you're going to do exchanges either on a Sunday or a Monday, depending on what you guys can agree to. I've seen 2-week on, 2-week off schedules. Now I will say that those, I think anything further than that, you're starting to affect your children a little bit and their consistency in their lives. And that's really what the whole purpose of all of this is to find the best interest of the children. Because that's the only thing the court is looking at when two parties go into divorce and they're starting to discuss children. There's two different standards in custody. When you go into a divorce, you go in on equal footing. The scales are not tipped on anybody's favor. You guys are exactly at equal. And you start piling on evidence and facts to the judge in order to tip those scales one way or the other. You may tip them in your favor. It may say physical custody to you. They may get tipped in the other favor, or they may not move at all. Y'all may just keep putting stuff on it, and they keep equal out, and the judge may issue joint custody at that point. But the idea behind all of this is that the parents are sharing responsibilities. And that's what happens in a joint legal, joint physical relationship. And in that scenario, they're going to alternate the periods of custody, but they also have to designate decision making. Because like we discussed, you're responsible under a joint legal scenario to continue to share in the decisions. You must inform the other party. When you get school reports back, or you get parent-teacher conferences scheduled, you better be telling the other party. Now, we won't get into the arguments that come up in court, but the other party probably should be taking some responsibility to find that information on their own. That's a pretty common argument. Other parts saying that parties take actions to prevent access to that information. Those are all different discussions, and that's what we end up having to litigate. But in a perfect scenario, the two parents are able to share that information back and forth. But, like I said, we've got to designate somebody as the tiebreaker, because they can't get along. That's why they're getting divorced. So, in that scenario, there are 6 categories that the court is going to look at, and they want to designate a decision maker in each one of these categories. And when I say designate a decision maker, again, we're talking about final decision, not the only decision, the final decision. You still must take input from the other party. But these 6 categories are medical and dental, they're education, religious. The code section says athletic, but the majority of everybody tends to use the word extracurricular, as athletic doesn't really encompass everything, and we see some holes in that. So we typically will say extracurricular. And then civic and cultural. Now, I'm always asked at the end, what is civic and cultural? And that's a very difficult thing to determine. It's a very hard thing to put your hand on, but it kind of depends on, again, the facts of the scenario. I've dealt with foreign nationals that culture is a real big important thing to them. I've dealt with people who were Eagle Scouts, and they wanted their children to be Eagle Scouts. So civic was pretty important to them. But generally, our disagreements arise around the big four. And as you can imagine, medical and dental and education tend to be the two that we argue the most about. They tend to be the ones that each parent has very difficulty in relinquishing. A lot of times when you have a joint legal, joint physical scenario and you're dealing with decision making over education, it may determine what school district the children go to. So as you can imagine, that becomes pretty important. But the court is going to require us to develop and designate in our agreement or in our proposed order who these final decision makers are. And if it's not in there, the court won't sign off on it. It's not a valid order under those circumstances. The court must get in a position where those are designated. Otherwise, we're going to have a problem when we get into these sorts of agreements and we figure out what's going on. And that's kind of some of the things that you do with joint legal, joint physical custody. The other scenario is a sole legal, sole physical. That is a very uncommon scenario. Essentially, that parent only has rights to visitation. They have no rights to access to information or be involved in decisions. The person who doesn't have sole legal, sole physical. That's a scenario in which you have one parent who has, for lack of a better term, either abandoned the child, shown zero interest in being involved, or has determined that they're making some decisions that are placing that child at risk. And that's the scenarios you get those sorts of things. In addition to child custody, there's two other things that are important that come up in our divorces, and it's alimony and retirement. And I want to touch on those just briefly. Retirement in Alabama. In order to be eligible for retirement, you must have been married for 10 years. Now, there is some cases that are trying to challenge this right now, but if you've been married for 9 years, 364 days, you are not eligible to your spouse's retirement. You can't even divide it. It's not a subject for the court to look at. Now, this gets in people's craw pretty bad, and it is not necessarily the best scenario, especially when you are trying to unravel a long marriage in which this person is dependent on this retirement. The other thing I want to talk about is alimony. I'm just going to touch briefly on, there's a couple of different types. It's alimony in gross and periodic. Alimony in gross is non-modifiable. It cannot be changed by the court. It's a one-time decision. A periodic alimony is always modifiable, and it continues forever until one party dies, cohabitates with another spouse for more than a year, or they remarry. There are advantages and disadvantages to both. One is taxable as income and tax deductible. That's periodic. The other one is not. But sometimes it may be important whether to modify it or not. And those are some of the things and some of the factors you consider when you talk about alimony. But alimony is always based on the needs of the party and the ability of them to meet those needs. Thank you so much.